Hi, I'm Tim Upsitnik, the General Counsel of TCDI. I'd like to welcome our attendees and panelists in today's webinar. TCDI and the Rabiej Litigation Center are sponsors for today's webinar, or hosts, if you will. TCDI is a e-discovery and litigation management provider of services. I've had the pleasure of working with John Rabiej for many years. His willingness to tackle the very difficult issues in litigation and develop solutions attracts many of us to his seminars and conferences. There are a series of 3 webinars, and John will explain a little bit further. But today we have the second of those 3 webinars. Today's webinar will talk about plaintiffs' discovery. Reviewing discovery that they receive from defendants. Although there is a robust literature on how defendants identify, preserve, collect, and produce ESI and discovery, that little is written on how plaintiffs manage and review voluminous documents. Understanding better how plaintiffs handle this volume of documents, particularly how they prioritize their work to get what they're searching for, will better inform defendants in the court as well as facilitate more effective e-discovery. I'm going to do a short introduction or bio for each of our panelists, and I'm going to start with our today's moderator, John Rabiej. John is the founder of the nonprofit Rabiej Litigation Law Center. He partnered with George Washington Complex Litigation Center for 2 years. Mr. Rabiej joined Duke Law in early 2001 after serving 1 year as the executive director for the Sedona Conference. He served as deputy director of the Bulch Judicial Institute for 1 year and director of the Duke Law Center for Judicial Studies for 7 years. Previously, Mr. Rabiej was the chief of the Rules Committee Support Office for 20 years, establishing heading the office that staffed the 6 Rules Committees of the United States Judicial Conference. Next, I'd like to introduce the Honorable David Campbell. Judge Campbell was nominated to serve as judge of the United States District Court for the District of Arizona by President George Bush in 2003 to a new seat that was created. The United States Senate confirmed him in July 2003 by unanimous 92-0. Our Congress doesn't do anything unanimous. Thank you for that, Judge. Judge Campbell was notably a member of the Advisory Committee on Federal Rules of Civil Procedure from 2005 to 2011 and chaired the committee from 2011 to 2015. While the Advisory Committee approved important changes to discovery-related rules that ultimately became effective December of 2015. Next, I'd like to introduce Alyson Oliver from the Oliver Group. She has a multifaceted career spanning over 20 years with experience as a lawyer and managing partner for the Oliver Law Group, where she provides a handling of intricate litigation. Oliver has the innate ability to identify and digest legal issues and explain them to clients and juries in non-legal jargon that allows for the ease of understanding. She has represented companies, classes, individuals, and the community as a large, often in complex matters. Next, I'd like to introduce Jacksy Bilsborrow from the Weitz Luxenberg firm. Jacksy is the co-chair of their Environmental Toxic Tort and Consumer Practice Group, which he joined in 2011. Jacksy represents victims of environmental contamination, toxic exposure, and defective products in complex litigation nationwide. Jacksy also represents farmers whose crops have been damaged by defective herbicide and other chemical applications. More recently, and something which is close to home, he recently was appointed to the Plaintiffs Executive Committee to litigate claims on behalf of the residents of East Palestine, Ohio, following the chemical fires resulting from the derailment of numerous Norfolk Southern train cars on the Ohio-Pennsylvania border. In April 2024, plaintiffs reached a $600 million class settlement with Norfolk Southern. And he has a list of many other successful litigation achievements. Last but certainly not least, I'd like to introduce Paul McVoy from Repario Data, Inc. Paul is the Senior Vice President and shareholder of Repario, which is an innovative, client-driven technology company focused on concierge-style litigation support. Paul has been at the forefront of discovery for 30 years, and I'd like to say, Paul, I've known you for all those 30 years, so it's a little scary. He was an early adopter of the technology-assisted review and has been a vocal advocate in support of its use ever since. Paul is an active member of the Sedona Conference Working Group on Electronic Document Retention and editor of the Sedona Conference Glossary, 5th edition. Thank you very much. John, I'll hand it over to you.
Thank you, Tim, for those kind words and your support. My association with Tim and TCDI goes back more than 10 years. I've relied on Tim and TCDI for their expertise in e-discovery ever since I first met Tim when I was the executive director of the Sedona Conference. My reliance on Tim and TCDI grew stronger when I became the director for the Center for Judicial Studies at Duke Law School, at which time I acquired and managed EDRM. And since June 2022, when I founded the Rabiej Center, I looked to Tim and TCDI to advise me about practices in the trenches in cutting-edge technology and e-discovery. I look forward to continuing working with them as we enter the new AI era, where they excel in. As Tim mentioned, this is the second of 3 e-discovery webinars. The first explained that millions of documents are produced in Mass-Tort MDLs, even if discovery is limited to a few general causation issues, because the definition of relevant under Rule 26 is broad and open to wide interpretation. And because lawyers understand the meaning of relevant differently, one side cannot blindly accept the other's production of documents as conclusive. So they demand as many documents as the court permits and make their own decision on which documents are relevant. A transcript of the remarks made by Judge Paul Niemeyer and Judge Vaughn Walker at the webinar is posted on the Center's website at rabiejcenter.org. A recording and a transcript of this webinar will be posted later as well. Now, Tim mentioned earlier the purpose of today's webinar. And the key point here is that we're hoping that this information will help both parties target discovery without reviewing and producing every conceivably relevant document. Now, TCDI and the Center will follow this up with a third webinar later this fall that explores how TAR and generative AI can be used to focus e-discovery even further. That will require joint training of the TAR or AI search tool. Now, having the parties jointly train the search tool is common sense and inevitable. Joint training recognizes what the Civil Rules Committee acknowledged in 2015. At plaintiffs, when they request discovery, are in the best position to know which documents are important to resolve the issues as they understand them to be. The plaintiff's input in searching information at the beginning, while training the search tool, would eliminate wasted e-discovery by defendants who base their searches on what they guess the plaintiff believes is important in resolving the issues. Now, until now, attempts at joint training have been frustrated primarily because defendants refuse to disclose documents during training, which they deem to be not relevant and not required under Rule 26. But without seeing these non-relevant documents, plaintiffs are not assured that the production omitted documents that they deem to be important in resolving the issues. Now, the defendants' and plaintiffs' concerns are legitimate and pose real obstacles to general acceptance of joint training. But these obstacles can be overcome. The center is developing best practices with the help of practitioners and judges, which will be ready for public comment early next year that address these concerns. Our next webinar will also address joint training. Now, today's discussion will address discovery in Mass-Tort MDLs, arbitrarily defined as MDLs with more than 1,000 actions. Since 1968, when the JPML statute was enacted, there have been a total of 40 Mass-Tort MDLs. Many of them are of recent vintage, with more than half, 22 Mass-Tort MDLs pending now. Now, we all know that every Mass-Tort MDL is different, and that judges and lawyers are skeptical about any proposed guidance that suggests uniform procedures, and for good reasons. But the lack of any uniformity in procedures comes at a cost. Judges and lawyers in Mass-Tort MDLs start from scratch and rely on case management procedures in one or two earlier MDLs or on one or two experienced MDL judges to develop their own case management procedures, including e-discovery procedures. Such an approach invites disputes and litigation because it is heavily dependent on subjective judgments of individual judges that are unpredictable. Now, this mindset against uniform procedures has led to many lost opportunities to efficiently address problems that regularly arise in Mass-Tort MDLs and has constrained the full use of AI. And while the number of Mass-Tort MDLs is small, any guidance providing uniform e-discovery procedures would have a far-reaching impact, because lawyers and judges involved in this type of litigation are the tops in the profession, and their views are influential. Now, new Rule 16.1 takes effect on December 1st, 2025. It requires parties in an MDL to submit a report at the initial management conference addressing and suggesting procedures to make MDLs more efficient. I expect that the rule and the revision of the Manual for Complex Litigation, which is due to be completed soon, will strengthen opportunities to provide more uniformity in procedures and make them more predictable. CLE credit has been approved for this webinar. CLE authorities require us to ask those seeking CLE, for CLE credit to confirm your attendance by responding to a question that I will ask later in the webinar. You can submit your response by inserting the answer in the chat space at the bottom of your screen. So let's start now with Alyson Oliver, who can talk about her experiences with managing huge volumes of documents produced in Mass-Tort MDLs.
Hi, everybody. I'm Alyson Oliver Bell Group out of Detroit, Michigan. I've been involved in a lot of MDLs, always on the plaintiff side, and there's always a ton of documents that need to be reviewed. Because the plaintiffs have the burden of proof, we're always concerned that we might miss the one document that might create liability or add to our damages story. So in every MDL I've ever been in, there's a lot of time spent, hundreds of thousands of hours spent doing document review. It has always been a staged review where you have lower level reviewers do the review first, and then presumably more seasoned attorneys doing a second review of the documents. So it takes a lot of time and it costs a lot of money to dig through all these documents. The joint effort sounds like it would be useful in regards to moving forward and seeing if we could train AI and do it jointly. I think the hesitancy on behalf of the plaintiff's bar would be the same concern that we already have, and that is that if we don't do a thorough review of every document that we can get our hands on, we might miss the big piece of evidence that might make or break the case. So I think it's good to be talking about joint review and trying to set something up along those lines. But I think there probably would be pushback from the plaintiff's bar and any limitation of trying to get documents that fit the term relevant and impede on our ability to review every document that we think we should have access to make our case and meet our burden.
Great. Let me drill down a little deeper then. So when the defendant produces the documents, and let's say there's millions of documents, by that time you probably have a plaintiff's steering committee formed. What's the next step? What does the lead counsel, typically they have the most responsibility. What does the lead counsel do? How does he advise the committee? Does he form a committees? I know it varies, but typically what happens when you got a huge volume of documents to deal with?
Right. So every MDL I've ever been in, either the court or lead counsel devises a discovery committee. And discovery can be offensive, defensive, the written discovery, depositions, and then there's document reviewers who are assigned to pull and review all the documents.
And so when they're assigned to do that, are individual law firms assigned to handle custodians, or are they assigned the first million documents and another law firm does the next million documents? How does typically, what's been your experience? What have you seen?
I've seen it done either way. It's more commonly done by custodians than by the numbers, but both ways have been done.
And how many law firms are involved to do the review of documents?
It really depends on the case, but it's a good number of law firms, 10, 20 law firms generally. How often when the documents are produced, in your experience, are they produced by keywords rather than tar? I understand, and we realize that the defendant may use tar and other methods to narrow down the universe, but the final production, is that done by what's been your experience? Keywords or tar, or maybe generative AI? Keywords.
Keyword. And when you get the keywords and the lawyers get, and let's say it's over 1 million, are they manually review them, or do you run your own version of tar to narrow it down? And if you do apply your own version of tar, how far down do you go? When tar classifies it 1 to 100, do you and you apply tar and you get to the, say, number 60th point, and everything past that, your next 100 documents seem to be redundant. Do you continue to manually review all the way down? What's been the experience?
Yeah, so it usually is the weeding out process is done by our own tar on behalf of plaintiffs. And at least in my experience, the goal has been to review every single document.
So what is the purpose of using tar to narrow it down? It classifies as 0 to 100. One would think, well, how do you address the concern that, well, you've got the top ranked documents, and say it goes to 60 from a scale of 0 to 100. Why would you want to go lower to that, particularly if you start sensing that this is all repetitive? Is it just a fear of missing out, that maybe that last document somehow will be the silver bullet, and that's what is feared?
Yes.
Okay. Do you have, when the PSC comes up with the assignments, do they provide, or does somebody provide written guidance on what the lawyer should be looking for on the defense side? As Tim indicated, there's a robust literature. And so they tell you, the initial interviews with that primary custodians, and then they come up with a list, and then they actually come up with a list of criteria that they farm out to all the lawyers. What's the experience for the plaintiffs?
Right. So that's pretty much exactly how it's done. But there's, initiation, if you will, nowadays via Zoom. Everybody sits down together, talks about, what we're looking for in the case. The lead counsel provides their guidance. We're the head of the discovery committee. If lead counsel isn't involved in the document review at that point, And then there's usually weekly or biweekly meetings to talk about the documents that have been found, whether, how substantial are they? How does it aid or hurt our case? And so on and so forth.
Great. Well, that was great. Let me move over now to Jacksy and probably go over basically the same types of questions and getting it from your perspective. Like we said earlier on, every MDL is different. And so the MDLs that Alyson has had experience may be different from what you had, and you've had different experience. So Jacksy, I'll let you talk about your experiences.
Sure. Thanks, John. And again, I don't want to just repeat what Alyson said. To a great extent, I agree with a lot of what she said, and it's been my experience as well. I think one point that I wanted to make is that when we talk about 1 million documents, that's 1 million documents at the end of the substantial completion portion of the production. But getting to the end takes some time, and it's not always an orderly, linear process, right? We're negotiating who we need to depose. We're probably maybe negotiating additional custodians. We're learning as this process, as the production process is happening. And so we have imperfect information at the beginning of the process, and we are trying to constantly refine the information that we have. It's happened more than once where we think our story will proceed a certain way, but we find out about a decision-making committee or a project that was undertaken to determine whether this product was going to be defective, things we didn't know until we got into the documents, and we have to adjust to that on the fly. So typically at the beginning of the discovery process, we are very idealistic, and we say we're going to look at every document, we're going to run every hot document up the chain. We have the regular meetings that Alyson discussed. We have a document review memo and says these are the key things that we want to look for. But as the production increases, the production rate increases, and as we have to start folding in things like depositions, privilege review, all of those things that compound as the discovery process continues. I do think it's more difficult to continue to look at every document, and I think with the AI products that are coming online now, I think I can see a world in which we don't need to do that. I think some of the document review platforms now have very good continuous learning or AI functionality. And I think it's only going to get better. It's grown by massive leaps and bounds in the last 2 years alone. So we have this problem of sort of imperfect information, learning as we go along. I think we are mostly using TAR tools and keyword searches once we get the documents, and typically, there are teams that are broken off. I've seen it done by deponent and key witnesses. And, a team will say, okay, we're going to go through the custodial file of Joe Smith. And that's done either through a mix of keyword searching, probably more keyword searching in my experience, but I think that's probably changing as these AI tools become better and better to perform the review. I mean, I'll just speak for myself, but I think that the plaintiff's bar generally is welcoming of tools that would ease the review burdens that we have. And as they get better, I mean, again, only speaking for myself, I welcome them. And I think those will cut the time and the manpower, person power needed to review these large document sets. So I'll say that's generally how the process works. Just and before you start hitting me with questions, John, I'll say in response to the joint training concept, I think it's a great concept, but I think it really does require full information sharing before you try to train whatever product you're trying to train. And, while I take your point that plaintiffs are in the best position to know the relevant docs that they want, I think that's true from a high level, but we often don't know the details, right? I don't know who the key custodians are, other than maybe the individuals in the firm or in the company that are public facing. Yes, I can tell you who the CEO is. Yes, I can tell you who maybe the spokesperson or the product manager for the key product is. But I don't know how it works on the inside. And so we need to have a process where we sit down and we talk about who the key custodians are. One thing I've done is, and we did this in the social media case, we asked, give us the list of people you provided with a litigation hold and tell us the position that they had within the company. And we got a lot of pushback for that, but the judge ordered it to be produced. And so then we had an Excel sheet of everybody in the company that got a litigation hold and the position they held within the company. And it was extremely helpful for identifying custodians that we wanted to talk to. So things like that, I think, need to happen before we can train a product to identify all of the relevant documents. It's the same thing with search terms. We're often told at the outset of the case, negotiate search terms, when we haven't seen how the employees actually talk to each other, right? Do they use slang terms for certain features or products within the company? Do they have a way of talking to each other that we don't have if we're not in that industry? I mean, the tech industry uses, just to take one example, the tech industry uses certain words and phrases that I don't think we use in law firms, right? So we need to know that before we can really negotiate the key search terms. And maybe there's a process where we do get some documents, we're able to review those, and we can actually see how people talk to each other. And although that leads to the other problem of we always get the hottest documents on the last day of the production schedule, right? So if we truly want to be able to converse in an intelligent way to train a product to go out and find everything, we need to see those good documents a lot earlier in the process. I don't necessarily know what the solution to that is, but I can tell you there's not a single MDL I've been in where we got all the hot documents in the first 2 or 3 productions. It's always at the end. So those are sort of some of my general thoughts. I think every case is different, in part because courts are appointing a group of law firms. So it's a little bit more difficult than having a top-down vertical structure within a single law firm or maybe 2 law firms. We have to figure out how we're going to make it work as a group of sometimes very disparate firms who haven't worked together before. And that's always a process. And sometimes it works better than others, but there's always some extent of which we're starting new in each case.
So it was a little bit unclear when you said that when you got what I thought you said was when you received the documents that were produced, you applied keyword and tar to it. Is that you guys, or is that the defendant who does the keywords and the tar?
So yeah, sorry if that was confusing. So typically what we're ordered to do is negotiate search terms with the defendants. And I mean, that can work in a bunch of different ways, but one way that it might work is defendants say, here's the search terms we think that we should use. And we say, no. here's the pushback.
Have you requested them, the defendants, to use tar, that you prefer tar instead of doing the keywords, or you just leave it up to them to tell you what they want to do, how they're going to produce and then negotiate?
I think we used to request that they use tar more than we do now, because we pretty much uniformly were told no.
Okay. All right. And from the defense side, I hear that they reject it because they don't want to disclose the non-relevant documents during the trainings, because they're not, they're not required to do, because it's not relevant. So I think the best practice is that's one of the obstacles I think we can overcome with to come up with tight enough language. Let me move on now. Thank you very much, Jacksy.
Yeah, of course.
To Paul for your comments now and your experiences.
Thanks very much, John, and thanks very much for asking me to be here. I think this is an important conversation to have, especially as technology is just moving forward so quickly. What was true last year or the year before is not true anymore, at least in my perspective. And just to give a little background, I started at a defense firm and handled MDLs for them and the collection, review, and production of those documents back in the day, where the only options were manual review of every document, maybe some keywords, but this was pre-2006 and pre all of that information. And I say that because, many of the challenges that later, when I worked for the plaintiffs firm, exist on the defense side. Not knowing what the document population is, not knowing how the individuals in the corporation communicate about the documents, not knowing exactly what documents you're looking for. So the challenges are similar, but different, because at the defense firm, you can just pick up the phone and call someone and say, can you please tell me more about XYZ? Where when you receive documents, you can't do that. You have to go through counsel, and it depends on the transparency of the client to the defense counsel and then the defense counsel to you. So I've also handled MDLs as a special master, right? So revisiting issues that have come up in MDLs, especially MDLs that have been receiving or inheriting document productions from previous MDLs that are overlapping in content, which I think is a big issue on the plaintiff side. Because on the plaintiff side, in a typical case, a fresh MDL, you get to negotiate what the scope of the case is. If the other side is open to it, you get to start negotiating keywords or technology-assisted review, and now generative AI. When you're inheriting a production, defense counsel rightly so thinks they've done a lot of the work that they don't have to redo. But you might not agree with how that earlier MDL production workflow was comprised or performed or, validated. So there's some special issues that you have on the plaintiff side, receiving productions that were made in a different litigation or related litigation, which are unique. So I have a couple thoughts on being a plaintiff receiving millions of documents. I've done it a number of times across a number of different kinds of cases. The Mass-Tort MDLs are a little bit different because you have bellwether cases and you have your own productions that need to be made. But the incoming productions in the Mass-Tort MDLs are a little bit unique because of how fast they come. You don't receive all the documents at once, but trying to come up with the ESI protocol, the search term protocol, the generative AI protocols are difficult because increasingly defense counsel has become less open to transparency, less open to doing things they don't have to do if they're not dictated in the law. Jacksy got it 100% right. Plaintiffs, in my experience, are much more open to new technology, much more open to new approaches, because plaintiffs pay for everything they're doing out of their own pocket. If they receive 5 million documents, they have to pay a company like mine, like Tim's, to host those documents, to run the technology, to look at those documents, and it can get expensive. So they're very motivated to allowing the other side, within reason, to use technology to narrow the production to things that are more valuable, so that once the plaintiffs get it, then they can dig right into the more important documents. The joint training, I think, especially now, is going to be a little bit different than what it traditionally was, right? So in a couple of very notable cases, it was, let's get the defense lawyers and the plaintiff's lawyers together in a room Let's open the box of documents that are going to be training documents, and let's go over them together and code them together, right? And so I think that was an effective approach historically. I think now that generative AI is here, now that documents and systems can be trained not with specific documents, but more with themes, with language, with understandings of what you're looking for, I think this conversation is advancing dramatically. Like I said, a year ago, we weren't having the same conversation. I've started in that room helping people go through documents one by one. We start with 1,000 documents. Let's train them. Let's come back in 2 weeks and see how the system did, how it's stabilizing. That fell out of favor when privileged documents started getting disclosed in that initial review, because rightfully defendants didn't want their privileged information coming out. Rightfully plaintiffs wanted to see the curated document sets that were training these TAR systems, because they felt like if you're training the TAR system wrong, one document mistake could then end up making a decision on 100,000 documents in the produced documents. Counsel said, you know, if we're giving you raw documents, there'll be other things in there unrelated that we don't want to disclose and we don't feel like we should have to disclose. So I see it from both sides. We moved from that joint training to, okay, well, let us provide you with documents that we want you to use as training sets. So they'd be more responsive documents, and that evolved into synthetic documents. And what a synthetic document is write your perfect document. Use the language that you want to use based on the facts you know, and we'll introduce this into the TAR workflow. Because the TAR workflow uses language. It doesn't matter if that language comes from a document that was created within the corporation or a synthetic document that was created with an amalgamation of all information you've learned up until that point. And now documents being trained in Gen AI need much, much less information. We're training documents for incoming productions and the segregation of those documents using 1,200 words or less. They're using a distilled version of the complaint, and they're doing a much, much better job than we used to do sitting in the room with 1,000 documents helping train TAR, into categorizing incoming documents into important, not important, issue or not issue. So I think we're seeing advances that are going to change this conversation, as Alyson alluded to, as Jacksy told us, in the next year, that are going to change this conversation. I'll stop talking now.
Well, good. I'm glad you hit it because it raised a question in my mind. Now, if you use that process, I would have thought if you have both parties jointly come up with this 1,200 words, if they agree on it, you get it into the machine, you get a bunch of documents that are produced, maybe you do a random sample of the results you have, you do it some kind of test case. But then you got Jacksy's problem where he says, this has got to be iterative. We learn while we go through this process. It's going to take time. I would have thought that once you get the results from that, then okay, Jacksy, you have an opportunity then to review those documents that were produced, and you may find something new in that, and then you'd send another prompt to the AI machine, and that's you may do a couple of steps. Is that what you guys envision, or is it? And then also the timing. When would you do this? Because again, Jacksy's concerned. I got to have some information first before I feel comfortable that the results from a machine are accurate.
Yeah, and it's a great point, John. And we're not solidified on a workflow that's going to work going forward. We have more of a general idea. There's two extremely important points that I think need to be raised here. One is validation of the process. Yeah. Regardless of how transparent the other side is or not, I urge my plaintiffs' clients to always have an understanding and an agreement on validation. Even if the other side won't share anything with you, if they share their validation, if they share how they're testing the documents or adherence to their view of what responsive is, it's a lot more encouraging on our side, on the plaintiff side, if they will be transparent about their validation, because then you can get insight into what they've done and how they've done it and how successful it was. The validation, I wouldn't agree on any process. I wouldn't agree on a manual process of doc by doc review without a understanding of validation. And The second point that I would want to make on this is that the advance of Gen AI is exponential, right? And so Jaxie's issue is based, and I'm speaking for Jacksy, and he can start yelling and screaming or raising his hand or whatever. But on the plaintiff side, TAR tools kind of require the exact language and exact themes in order to really target what you're going for. Gen AI is not that way. 1,200 words of generally how you're going to use the language will pull back a reasonably high percentage of documents, even if those documents are not in English. And that's very telling because you can say, I'm looking, and I'm going to use a antitrust thing because I think that's more widely applicable here. But if you can go in and say, I think company X was conspiring with company Y to fix prices in this market, and I'm thinking this because I see these results, that's all you need to say for it to have a very, very, very good understanding. Where before you had to give it document examples, you'd have to give it results from the market, you'd have to give it empirical information of how the market has risen or lowered. The Gen AI tools understand what you're looking for and why you're looking for it. And yes, there is going to be iteration. I don't want to say there's not going to be iteration, but Jacksy won't have to wait until the last day of production in order to see the hottest documents in order to curate a good or a better prompt for the other side to run. And prompting is much different than sitting in a room training documents, in my opinion. And Jacksy, now you can yell at me. Alyson, you can also yell at me.
I completely agree with everything Paul says.
So before I go to Judge Campbell, ask him for his comments, I just want you to probably confirm something that's very obvious, but I think it needs to be underscored, is that AI right now is pretty good. In 6 months from now, it's going to be really good. In a year from now, who knows? I mean, the future is coming very quick, and these improvements and enhancements are very remarkable. And even at today, it's how good is it today? I mean, compared to TAR or manual review?
It's hard to quantify because not many people have done empirical studies on it. We used to talk about manual review being around 60 or 70% accurate when you went back and you validated it. In TAR, we could get to the 80%, with a review and then a check of that review. We're getting closer to 90% now with Gen AI. And this is anecdotal as opposed to, I can't point to 4 or 5 studies, but it's what we're seeing in the everyday. And I work on just as many defense matters as I do on plaintiffs matters at Repario. And we're seeing the same results on raw documents that come in on the defense side. We're getting to good recall and good understanding of the documents in the 90% range using these tools before we were at the 80 and with manual review in the 70, 75 range.
Great. Well, let me go over to Judge Campbell. And Judge Campbell, you got the floor. Any comments on what you've heard and from the judge's perspective?
Sure. Nice to be a part of this call. Thank you, John, for setting it up. John and I go back 20 years when we started working on rules together in 2005. I respect his work. It's been interesting for me to hear what the attorneys and what Paul have said about their practice because it's quite consistent with my experience. My experience in the MDLs I've handled in the large class actions is that everybody uses keyword searches. And it was interesting to see the comment from William Belt a minute ago that in a recent forum, he saw a survey taken and 95% of the people said they use keyword searches. And this is a decade after the advent of technology-assisted review. It's also interesting to me to hear Paul talk about coming up with a 1,200-word description that will help AI more accurately retrieve documents because, in a sense, that's a keyword description that you're handing to AI. Now, I know there's a different algorithm that's going to do the searching, but still you're looking at keywords. I have also found, as has been mentioned by Jacksy and Alyson, that the primary focus in these large cases is on custodians. I think particularly for plaintiffs who don't yet know the language and the details of what went on behind the scenes of the defendant, They want to start with the people who are having the conversation, and they want to get the production of everything that's relevant from those individuals. And so I have seen more disagreements about who the custodians should be than I have about what technology should be used or even what keywords should be used. Paul mentioned previous productions. I have had MDLs where there was previous litigation related to the product, whether it was personal injury litigation or patent litigation, and good attorneys have agreed on the production of that already curated set of documents that are very relevant to the product at issue. One reality that judges deal with is, John, you're asking the question of what plaintiffs are doing after they get the documents for their review, and often what defendants are doing before their production. For most judges, in most cases, that's behind the curtain. We don't see that. We don't know what is happening, and so we don't regulate what is happening in those settings. Obviously, if the parties come to a disagreement, we do. As I listen to this discussion and Paul's, I think, helpful suggestion that things are changing and AI is going to make a difference, I continue to think that there are some basics that judges will fall back to, no matter what the method is, whether it's keyword, whether it's TAR, whether it's AI. Those basics, from my perspective, are first and foremost active judicial case management. A judge who is actively engaged in managing and monitoring the case. Now, I know those of you on the call can't do much about that. I will tell you, on our side, we try to do something about that. But I found when I litigated large cases and as a judge, if the judge is paying attention, if the judge is available to respond quickly to disputes, if the judge is holding parties to a schedule, most of these problems, I would say the vast majority of these kind of problems get resolved, especially in an MDL or a big class action where you've got good lawyers on both sides of the case. It remains true. There is a common instinct on the part of defense lawyers that I don't want to disclose anything I'm not required to disclose. So the notion of voluntarily sharing information is hard in lots of situations to persuade lawyers to do. And yet I have found good lawyers recognize that's the most effective way to serve their clients. That's the most economical way to move to the really dispositive parts of these cases. And fighting the small skirmishes over whether I'm going to give you my keywords or my hit list or something like that is really not a very productive way to litigate, especially if you've got an active case managing judge who's going to watch it and just not really tolerate a lot of disputes like that. A few more basics. It is always true that the lawyers will do a better job of figuring out how to share information than the judge will do. That's always the case. And so my perspective as a judge is, if I can get the lawyers to talk, if I can let them know I'm watching, if I can give them a reasonable but fairly short time to do it, and then I'll tell them, if you can't agree, then at the end of the process, I will decide it, and I won't do as good a job as you will. The lawyers virtually always find a way to figure it out. Something that judges talk about in this area, and that you've all mentioned, is this notion of transparency. I think that in big cases, they're just not going to be litigated efficiently if the parties aren't transparent about how they're searching for documents and what they're searching for. So, for example, I've had cases where I order the defense to disclose the hit list of what they got from their keyword searches. And I've heard arguments, oh, that's a work product, that's what we're doing. And I'm saying, no, that's relevant because, as Paul said, it's a validation of how accurate your keyword search is. And I'm not going to manage it well if I don't know that, and the other side isn't going to trust your keywords until they see it. Jacksy mentioned the notion of requiring one side to disclose their litigation hold list. I've never had the plaintiff's side asked to do that, but I will tell you, not hearing from both sides, my inclination would be, yeah, that's relevant. That shows you right there who the relevant custodians are within the company. That kind of transparency, whether it's required by the judge or recognized by the lawyers, to me, goes a long way to solving many of these problems. The other two general comments I would make is that most judges, the vast majority of judges, do not understand technology-assisted review, do not understand artificial intelligence. So if you are going to take a problem to the judge, there needs to be some good explanation and some transparency about what's happening. The last point I will make is that in most federal districts, the judges are very busy. The district judges are working overtime. They're working on weekends. If you go to them and say, Judge, we've got a significant discovery dispute, and we want a lot of your time to address this, it's a hard thing for a judge to say, okay, do I spend the next 2 days helping these parties fight over search terms, or do I do a better job on the motion for summary judgment I'm working on and the jury's instructions that are going to make a difference next week in trial? You can understand why judges get a bit impatient with the skirmishes of discovery. So what I will do in a situation like that is, if I have lawyers come to me and say, the plaintiff says, you know, the defense has seriously withheld documents in their privilege log. We've got 3,500 documents listed, and we can tell from looking at them that most of them aren't privileged. And the defense says we did a careful review, we double checked it, it's all privileged. And they kind of lay that problem on the table in front of me. What I will say is, okay, I'm going to let the plaintiff pick from the defendant's privilege log 20 documents. I'm going to look at those. I'm going to have the defendants then send me those documents. I'm going to look at them and review them, and I will give you my view on what's privileged and what's not on those 20 documents. And then I'm going to require you to sit down and solve this problem with the guidance I've provided. That has the benefit of me spending an hour on that issue, but they're getting input from an active case managing judge. They have a pretty good idea how the judge is going to rule if they give him, heaven forbid, 400 documents or her 400 documents, and they always solve the problem after that. So if you can figure out a way to help the judge provide input in an economical way for the judge's time, I think that will help you in resolving cases. So, John, those are just a few thoughts I have.
Thank you very much. Let me keep talking about that last point. Paul focused on or highlighted the fact that the validation process is critical. And that's what we ought to be concentrating. And I agree with that. You indicated that we need to have active judicial case management. The lawyers want that because they want to know which way the judge is going to make the decision. They need a little record to see which way you're deciding, because they don't know how, they may not know which way you may be leaning. Now, in TAR ranks millions of documents on a scale from 0 to 100. When we're developing best practices, we're going to expect that parties are going to dispute the classification of the documents of the cutoff point. In other words, they'll come off to a point, say 70 on the scale. Everything above 70 is responsive. Everything below is non-responsive. What's going to happen inevitably is there'll be a dispute that documents immediately below that 70 are responsive, right? So the key point is that those documents are probably relevant. Probably 0 to 100, they're probably all relevant. The point is that they may not be proportional to the needs of the case. What information would be the best for the judge if you come up with that type of a dispute where the lawyers come up and they say, Judge, we can give you 100 documents below number 70, or we can do a random sample of documents there, and we can identify these documents that we think are responsive, and these are non-responsive. And what they're doing is they want to look to you to see which way you're going to rule, and then that kind of gives them, directions in the future.
So is that question to me, John?
Yeah.
I've never had that question put to me. If I did, I think what I would do is I would say, okay, defense attorneys, you say 70 and above is relevant. Plaintiffs' lawyers, what do you say? And let's say hypothetically, they say, we want to see everything 40% and above. And of course, to do that, I think they would first have to be satisfied that this TAR system is reasonably accurate. I would then, I think, and the call for me is relevant or not relevant. And I understand proportionality comes into that. I think what I would do is say, okay, defense attorneys, you give me 10 documents that fall in the 60 to 70 range, 10 that fall in the 50 to 60, and 10 that fall in the 40 to 50. 40 is the plaintiff's cutoff. And I'd say, I'm going to look at them and I'll tell you whether or not I think they need to be produced. And you use that information to then decide where the cutoff point is. And then I would say to counsel, after I give that to you, you've got 2 weeks. We're going to set a hearing 2 weeks from now. You got 2 weeks to figure out what the right cutoff is and what you're going to come up with. And if you haven't solved that problem, then in 2 weeks, I will be here, we'll talk, and I'll make the decision, and it won't be as good a decision as you all can make. But we're going to get it resolved in 2 weeks because we got to get these documents produced. And the parties would know, I think, from my history in managing the case, I mean that. We are going to resolve it in 2 weeks. It's amazing how lawyers spring to work, figure it out, and get it solved, when the alternative is to lay it in front of a judge who may not do as good a job as they will.
Tim just reminded me, I got to ask the question for CLE credit. So for those of you seeking CLE credit, please insert in your space, yes. Just put in the word yes, Y-E-S. That will confirm that you've attended it. And going back to you, Judge Campbell, the other part is validation, is that once the parties have agreed to the cutoff point, and then they do a random sampling of the documents that are non-responsive. And they'll come to you back and they'll say, and they did this analogy, and it was interesting. They did a random sample of 700 documents. Plaintiff said there's 60 of them were responsive. So the special master in that case, who was a former magistrate judge, found that 30 of them were not responsive, and that 30 of them were responsive but marginally relevant. And then he just he didn't ask that the discovery be redone. And those are the types of issues we're going to be faced with in the best practices. They're going to be disagreement, and because relevant is so broad, you can make a legitimate argument that a lot of documents that are below a cutoff point, maybe all the way back to the bottom. And in fact, at 3M, they went through this process, and 11 million documents were produced using TAR. And then afterwards, they still did another search because the plaintiff made an argument that we found some in the illusion test that were there. So that's your 12 million. So what we're doing is trying to figure out best practices. I know I'll put you on the spot now, but the lawyers, you understand where our best practices, where our thinking is coming from. And we do think this is a good opportunity at this time because Rule 16.1 is going into effect on December 1st. If we can provide some guidance for lawyers and judges to think about these matters, I think it's a plus because I think we know the problem, where the disputes are going to occur, what the obstacles are, and the obstacle to joint training on the defense side. If we allow in-camera examination of documents withheld and limit it to 25 documents, defense counsel tell me they're going to withhold 5 to 10 for embarrassment or other reasons, that it'll work from their standpoint. It may work for the plaintiffs as well, but there are obstacles. I think you can get to them, but I think the key point, like Judge, that you recognize, is that AI is coming. It's getting much better, and we're starting to see a little bit more momentum to facilitate the use of AI. It may take time, but that's what we're here for. I want to thank everybody for their comments. I thought this was a wonderful discussion. This is recorded. It'll be posted on our website. I want to thank TCDI for co-hosting this. We'll come up with a third webinar for time to be scheduled where we're really going to focus on the joint training. If any of you people have comments, suggestions, like I said, we are in the midst of developing these best practices. We've got, I think, a pretty good draft right now. We're refining it, and we will publish it early next year and for public comment and even get it better. So once again, I want to thank you all for your time, for your attention, and have a good day. Thank you very much.
Thanks, John. Bye, everyone.
Bye now.